For a lawyer with an academic interest in the Brussels regime, it is sometimes easy to be blinded by the wealth of case law from the Court of Justice which concerns jurisdiction. Indeed, that is the great majority of the cases, both from the Court of Justice and from the national courts. But this is not the foundation of the regulation or its predecessor, the Convention. Recognition and enforcement is very much at the heart, in accordance with the Union objectives of free movement, but also the objective of establishing a framework for closer judicial cooperation and for nourishing mutual trust between member states and member states' legal systems. It is also, from a practicing attorney's point of view, the most important part of the regulation. My clients are less interested in the finer points of jurisdiction and more focused on the end result. How will I get my money? And conversely, how will I prevent others from getting at my money? We will today, in our contribution, focus on recognition. We will hear much from our esteemed colleagues later today on enforcement, but we thought that we would try and put focus on this sometimes underdeveloped aspect of the regulation and highlight some practical and theoretical aspects which raise important questions, not only of the relationship between the regulation and national legal systems and national law, but also of mutual trust between the member states and their judiciaries. The smooth operation of a system such as the one established by the Brussels regulation requires not only a set of thought-through rules, but openness and familiarity with judges from other member states. In my experience, and as mentioned in your introduction, Professor Sjövall, the very fact that a judgment from other member state looks different from the judgments from your own member state can be a significant threshold. And it immediately creates a defensive attitude which can lead to objections being raised. So the difficult question is, how do you bring about trust? This question came up at a seminar in Stockholm some time ago when the Court of Justice and its president visited the chairman of the Swedish Supreme Court. At the time, he created a bit of a fuss at the seminar when he honestly and truthfully, as I see it, said that you cannot force trust by legislation. It is a matter of fact that Swedish judges trust the judicial systems of our neighboring countries, and their judgments and orders are enforced even though you could say no, while judgments and orders from faraway member states are treated much less generously. The problem that we would like to raise today concerns recognition, and in particular, the res judicata effect of judgments. And I would like to begin by describing a case from my own practice. Maybe I'm going too far here. And it concerns a case where an Italian company was awarded a contract for a very big construction project in Stockholm. After 2 years, the Swedish authority, which had ordered the project, cancelled the contract, alleging many and serious breaches of the contract. Shortly thereafter, the Italian company sued the Swedish authority in 2 cases in the courts in Rome. 2 cases, 2 different bases, legal bases, not claiming damages on the basis of the termination of the contract, but in one case on defamation, and the other relating to a loss in connection with a bank guarantee. Now, none of those cases relate directly to the termination itself, but in both, the question of whether the termination was valid, legal, comes up as an incidental question. Thereafter, the authority sues the Italian company in the courts in Stockholm, asking for a declaration that the termination was lawful. And so both the Brussels regulation and the national legal frameworks come into play. Now we go here. Now, the regulation contains, as you are all well aware, its own regime for dealing with lis pendens, based on the French concept of même objet, même cause. This doctrine is used to determine when a court seized has to dismiss the action so as to avoid parallel proceedings about the same thing, giving rise to a risk of irreconcilable judgments. But in this case, no question of lis pendens arose. The requests for relief in the Italian cases have been formulated and drafted to avoid this. This means that we have a couple of cases ongoing in parallel, one in Sweden and two in Italy, where the main question in the Swedish proceedings is also an incidental question in the Italian proceedings. And the question, of course, is what will then happen?